The Law Society of Kenya is opposed to proposals made by President William Ruto to change the constitution. LSK President ERIC THEURI terms the president's proposals unconstitutional, with the lawyers' body asking Parliament to protect the constitution. Citizen TV's ABDIKADIR reports on yet another attempt to change the country's supreme law 12 years after its promulgation.
The lawyers' lobby says President William Ruto's move seeking to change the constitution is unconstitutional and that Parliament should not consider the proposals by the head of state.
We therefore call upon Parliament, that is required under Article 94, subsection 4 of the Constitution, to protect the Constitution and protect democratic governance of the country and the citizens of Kenya, to rise up to the occasion and safeguard the gains made under the Constitution.
In his proposal, President Ruto said, "I propose that Parliament considers an amendment to Chapter 9, Part 4 of the Constitution to establish the office of the Leader of Official Opposition." The President bolstering his argument with the claim that the Constitution fell short in the provision of clarity on the full post-election fate of the minority side, saying the bipartisan approach between the majority and the minority sides does not extend to its full logical extent. The President also proposed the establishment of a formula that will guide the computation of the gender ratio in the National Assembly and to entrench various funds in the Constitution, including the National Government Constituency Development Fund, the Senate Oversight Fund, and the National Government Affirmative Action Fund. The head of state also pushing for cabinet secretaries to be accountable to Parliament. With his proposal, and I quote, "I recommend and request Parliament to consider the formulation of a mechanism within its standing orders to facilitate the participation of cabinet secretaries and chief administration secretaries in parliamentary proceedings by responding to questions raised by members of the National Assembly."
The amendments are being initiated by the President, contrary to the decision in the BBI case, and so therefore they should not see the light of day in Parliament, as there being a very clear precedent that has been set by the courts.
The Law Society of Kenya says President Ruto now wants members of the bicameral Parliament to spearhead the process despite the Supreme Court ruling on the Constitution of Kenya Amendment Bill 2020, affirming that the head of state lacks authority to initiate changes to the country's constitution. The core values and principles as laid out in Kenya's Katiba 2010 are transformative and progressive. And while it's inevitable amending the country's supreme law, many questions do come up. Is the process to change the country's constitution constitutional as the Constitution envisions? For those driving any amendment, have they lived by the principles of good governance and constitutionalism? 12 years since the promulgation of Katiba 2010, has the country's constitution been accorded the right environment to thrive? The process that led to the birth of the country's Katiba 2010 was people-driven and people-centered. How willing are those driving any amendments going to engage the Kenyan people who are supreme in a robust manner? AYUB, Citizen TV at the Law Society of Kenya, Nairobi.